Hi, this is Kelsey Vukowski for AP Gov, and in our final installment on the judicial branch of Part 5 of Unit 4, we're going to be looking at democracy and public opinion and how that all affects the judicial branch. So the courts in democracy, courts are not very democratic to a large extent because justices and judges at the federal level are appointed. They are not elected, and it is very difficult to remove judges and justices who are going to serve for life. There are actually only three ways that a federal judge or justice can be removed, and that is the first one, being impeached and being found guilty of those charges and being subsequently removed. Number two, retiring, which occasionally does happen. And then number three, being death. Other than those three ways, very difficult to remove a judge or justice, again, at the federal level. Although in other states, sometimes you do have elections. You see that especially in southern states too, at the local level. Courts do often reflect popular majorities despite the fact that they are not very democratic. And we'll get to that in the next couple slides. Groups are likely to use the courts when other methods do fail, which is going to promote pluralism. We said that ultimately when interest groups are not successful with Congress or at the legislative level, they will turn to the courts, and that will be in the form of class action lawsuits. That will also be in the form of amicus curiae briefs. So certainly interest groups have a number of different ways in trying to influence the judicial branch. Nevertheless, there are still conflicting rulings that lead to deadlock and inconsistency, especially on the courts of appeals, which you might have one court ruling one way and another court of appeals ruling another, and that's where the Supreme Court will step in and have the last say. So with respect to popular opinion, courts are not entirely immune from public opinion. This is very important to understand because there's typically some type of question or FRQ that alludes to this, or you can intertwine this in. Keep in mind that justices are appointed by the president, and the president is going to choose that justice partially because of that justice's political ideology. If that ideology of that justice is so extreme, the president knows he or she is going to, receive a lot of flack for that appointment because the public doesn't like it, well, then that person's not going to be chosen. So right there, you have public opinion influencing the president. Also, highly political process for a branch that is really supposed to be the least political. Remember, in Hamilton's Federalist Paper number 78, it's supposed to be the least political. That's why they serve for life. But they're not, by any means, at all, going to be immune from public opinion. Keep in mind, justices are human beings, just like you and I. They follow election returns, they read newspapers, they receive political mail. And, they understand that if they go against public opinion, their ruling could be ignored because, for example, the justices do not have the power of the sword nor the purse. So they are reliant upon the other branches to carry out and adhere to their decisions. So if they go too far out the domain of public opinion, that's going to be difficult. Good example of this is Brown v. Board of Education. Even though that they ruled that segregation is illegal, you still have a number of schools, even a decade later, refusing to integrate, and they're blatantly disobeying the Supreme Court's ruling. But if you look at this table below here, in table 10.8, the Supreme Court and the American public, most of the time you're going to see that they're going to rule in favor of basically what the public opinion has. So certainly you're going to see that here. Now, one of the major roles of the judicial branch, unlike other countries, is making policy. They interpret the Constitution or law. They extend the reach of existing laws and designing remedies that involve judges acting in administrative or legal ways. Remember the power of judicial review by ruling a law unconstitutional or broadening a law, or, for example, allowing for integration to take place, ruling against segregation. Right there, you are making policy. You are declaring a law unconstitutional and making a new law, sometimes in ways of expanding the law. So that is very, very important. Now, their measures of power of the judicial branch. Number of laws declared unconstitutional has been over 160, so certainly you see their power there. Prior cases overturned in which you're not following stare decisis, remember letting basically the decision stand, over 260 cases since 1810. The extent to which judges will handle cases once left to the legislature, political questions, well, obviously we said in the other video that they cannot handle hypothetical questions. Should Congress fund this particular program or hypothetically rule on a proposed law. Remember, Supreme Court and the federal courts only rule on actual cases. The kinds of remedies imposed, judges may go beyond what is narrowly required, so they can at times make remedies. What must be done to correct a wrong situation? Right there, you are enacting policy. And typically this might apply to a large number of people, such as segregation. And really the basis for sweeping orders can come either from the Constitution or from the court's interpretation of federal laws, from past laws or past rulings or precedents from past courts. So really the scope of judicial power, really there are two main philosophies here. You have judicial restraint, which judges should play a very minimal policy-making role. This is very much in line with the doctrine of original intent. What did the founding fathers believe? What were their intents when they were designing the Constitution? And you see a lot of conservatives really endorsing judicial restraint. The other philosophy is called judicial activism. Think in a sense that activism, you are really making policy. You're being very active. You're not playing this minimalist role like you would with restraint. You're literally restraining yourself. In activism, you could create a new constitutional ground. So again, these are two different fields of thought of judicial philosophy, but you do have those who say that really it's not up to the judicial branch to make policy, and you have others saying, no, well, the judicial branch should right these wrongs. They are the ones who should step in. So you have different philosophies here. So views of judicial activism, certainly supporters are going to say, well, the court should correct injustices. And if you've looked at history, a lot of injustice has been really remedied through the Supreme Court. Courts are often the last resort for those without power. Certainly that is important. Whereas critics are going to say, well, judges lack experience in managing complex institutions, whether it's pertaining to schools or prisons. Initiatives require balancing policy priorities and allocating public revenues, that being a role of Congress, and that the courts are not accountable. That is a very legitimate criticism of judicial activism, that really you have these unelected officials making these major policy decisions, and it really takes we the people out of the equation. It's immune to popular control because once that justice is appointed, you're serving for life. So that is a major criticism of that. So one issue, though, with the courts as policymakers, as I said earlier, is with judicial implementation, that their court decision has to actually affect the behavior of others. And how do you do that? Well, you're not going to see anyone on the Supreme Court waving a sword or going in and forcing people to abide by their decision. It's not going to happen. So they are dependent upon the other branches to carry out and adhere to their decisions. So Congress or the president can sidestep or ignore the decision. Good example of this, as you see here, being segregation ruled unconstitutional and still continuing after 10 years, but also think of Andrew Jackson from U.S. history, where he was not supposed to remove the Native Americans under the Indian Removal Act, and yet he did so anyway. So ultimately, decisions affecting central government agency usually become effective immediately when you're looking at, for example, the EPA on whether or not limits they're imposing on carbon emissions is constitutional or not. Those typically are going to be carried out, but when you're reliant on other branches such as Congress or the president, can be a little bit more cumbersome. Based on a historical review, as the court and the policy agenda certainly see Marbury v. Madison giving that power of judicial review and in a sense basically becoming a policymaker. And over time, this has significantly expanded the power of the national government. Perhaps the best example is under Chief Justice Warren, which was known as the Warren Court, which was best known for the expansion of civil rights and liberties. You should be aware that the Warren Court is certainly associated with expanding civil rights. Under the Burger Court, you see a little bit more conservative, but holding up the very famous case Roe v. Wade, which will be discussed in Unit 6, dealing with abortion. And then you have the Rehnquist Court, much more conservative and limited liberal rulings from the past two courts. But definitely, again, know that the Warren Court is definitely big for expansion of civil rights. We're talking Gideon v. Wainwright. We're talking Brown v. Board of Education. That is very important to know. So understanding the courts, certainly the Supreme Court rulings in which federal statutes have been found unconstitutional, a mere two for quite about 60 plus years, you've noticed you've had higher numbers than others. And again, that can really depend upon the court's view of judicial activism. And Chief Justice Warren's court was known for being an activist court. So again, you have different philosophies. But there are checks on the judicial power, and this is very important to know. As we said earlier, judges have no enforcement mechanisms. They cannot force anyone to do anything. They can rule, but they are, again, dependent upon the other branches. In addition, remember that all justices have to be confirmed by the Senate. So that, again, is a check on judicial power. They can certainly be impeached, meaning being brought up on charges for bad behavior, such as taking a bribe. Also, Congress can change the number of justices and judges at any time. That is important to know. Public opinion, certainly as we talked about earlier, that if they stray too far outside of public opinion, it may not, the ruling may not be adhered to, as we saw with the Brown v. Board of Education example. Congress can revise legislation to be clearer, to be a little bit more narrower, to be in line with the Supreme Court's rulings. So that's one way to get around it. And a big way is amending the Constitution. While this is, of course, very, very difficult to do, if there's a law that was made or a law that was declared unconstitutional, all Congress would have to do, and I say all, they would have to just put in a new amendment. And if that became adopted as an amendment of the Constitution, then that's one way to get around the Supreme Court's ruling. And then lastly, altering the jurisdiction. Certainly Congress has that right and role and could do that. And again, that's one way to affect judicial power. So in summary, judicial policy making and implementation occurs in lower federal courts and state courts. That's important to know. It's not just at the Supreme Court level. Many important questions are heard by the courts, but remember, they only have so much time, and really a lot of their decisions are going to be limited to some extent by precedent, past examples of how courts have ruled. And typically speaking, they do not like to overrule precedents. Let the decisions stand, stare decisis. And then even the unelected courts do promote democratic values in the sense that they are, of course, trying to adhere to the Constitution. They try to right injustices as they see fit, especially during the Warren Court. So let's end with a review question. Which of the following actions can Congress take if the Supreme Court finds a federal law unconstitutional? Take a moment, pause your screen. All right, and if you said choice D, try to amend the Constitution, you would be correct. You cannot appeal the court's decision because the Supreme Court, of course, is the Supreme Court of the land. Formally request that the president veto the Supreme Court's decision. Of course, nobody can veto a Supreme Court decision. Remove certain members of the court and replace them with new members. Absolutely not, because they serve for life, unless, of course, they are brought up on charges and subsequently found guilty and removed. And then reenact the same law? No. If they reenacted a similar law and fixed the issue that the Supreme Court had with it, then that would be fine, but you cannot enact the same law once again. So best answer here is trying to amend the Constitution. Very difficult to do, but hypothetically speaking, that is one way that Congress can get around a Supreme Court decision.